NTV tonight. We are joined by George Musisi, a human rights lawyer who has handled several cases in the military court martial to analyze the decision by the Army Court to transfer several case files involving civilians to the Directorate of Public Prosecutions. Mr. Musisi, you are welcome.
Thank you.
In your view, is this the legal breakthrough that will enable civilians get justice fairly in the future?
Of course, it's in compliance with the Supreme Court directive judgment that all files which were before the court martials involving civilians should cease, and all of them should be transferred to the civilian courts. By the very nature of civilian courts, it means that they have to go through the DPP, the office of the DPP, who is supposed to scrutinize them afresh. Indeed. It doesn't matter what status, what stage you are at, because the DPP is supposed to work independently without the guidance or direction of anyone. They are only supposed to be guided by what the law says and what the facts reveal. So that reveals what is going to be happening before they reinstitute charges. They may choose not to reinstitute charges if there is no evidence of a crime committed. They may choose to institute either stronger charges or lesser charges. So now all eyes are both on the Army and the DPP. One, for the Army to see that the files are transferred, and then to the ODPP to say what next, because we know that a number of people are in custody as a result of that and pending the next decision of that office. Mr.
Musisi, the government is bent on amending the UPDF Act to give powers, of course, to the military courts to continue prosecuting civilians. What is the likelihood that this can be achievable, and what are some of the long-term legal consequences if it is achieved?
The plans of the amendment, it has two limbs to it. One, it could be an amendment to comply with what the Supreme Court said, because remember, this judgment even talked about what the CJ called advisory orders, saying that these are some things you can change. They talked about things like composition of the military courts, how they are appointed, the competence. The CJ advised on the appointment of the people who sit there, for instance, that they can be nominated by the CJ, they should be lawyers, and so on and so forth. So there are some issues that court ordered that the law should be amended such that there can be some bit of a fair trial in those courts, even for soldiers. However, of course, some people have taken it, and including many NN people, that we are amending to defeat, such that we can bring the trial of civilians. Of course, a legislation which is intended to defeat a court judgment is unconstitutional from the onset. Like, the Constitution is very clear. So right now, I don't want to be presumptuous. Do they have a right and legitimate issue to amend? Yes, it's good that they have withdrawn, because they need to bring a comprehensive amendment. Some amendments may even touch the Constitution. They may even have to bring up a constitutional amendment to do it properly. When they bring it, then we can have a chance to discuss their proposals. Right now, they haven't laid any proposals on the table. If they are in line with what the Supreme Court advised, well and good. If they're not, of course, at some time, we'll have a chance to give an input in the public, and if Parliament passes it, like it has passed some unfair laws, we'll have a chance to challenge it in the courts.
Mr. Musisi, thank you so much for talking to us. Well, moving on.